What'd you read about this week?
Stuff.
We're about
The
a lot of
president.
what the president.
Article 2.
President? Courtney said president. I love it. Thank you for answering. That's cool. She said president. Before Matthew speaks, what'd you learn about the president? Then I'm going to go to Matthew to fill in any blanks.
What he does.
What he does. What's he do?
He's the
President.
chief.
He presides. He's the president.
He's the commander-in-chief.
Commander-in-chief. What's that mean?
He's the head of the military and defensive, well, not like the army.
Tell you, a thought came to me one day. See, I study, watch documentaries, watch real, incidents. On 9/11, it was the vice president that gave the order to take down any airplane that does not comply with instructions. So there were fighters in the air, and it was the vice president who gave the order. So I wondered, you know what I've never done? I've looked up, what is he acting as deputy? Is the vice president the commander-in-chief? But one of the things in there is it talks about if the president is not available, he's supposed to communicate to Congress that the vice president is standing in for him. And I thought, I wonder if George W. Bush called up Congress and said, oh, by the way, for the next 4 hours, I'm, talking to second graders in Florida. Please do anything that the vice president tells you. I don't know. So I'm gonna have to look into that. Is there any kind of thing that they've done in their pre-planned procedures where the vice president's starting to speak orders? I don't know. So something to think about. Okay, so that's commander-in-chief. What else? So we talked about it was the executive branch, right? Article 2 of the I hope to bring to this is a deeper understanding so that you understand what ought to be the actions of the president. Okay, he's been elected, now what? What should he do? How he or she, the person, should act in relationship to Congress and the judiciary and all that other kind of stuff. So that's really my goal, because right now we're shifting you into your civic duty realm. You're shifting into that status and station of life where the government shall be upon your shoulders, in proxy, okay? Really, it's on Jesus' shoulders. But ultimately, as you representing Jesus, you're doing your part as a minister of God for the good. The government is of the people, by the people, for the people. They are your trustees. Article 1, Section 2 of the Virginia Constitution reminds us of that. So what are you going to do? What should you know? How should you hold an agent accountable for you? So let's go to this handout I gave you. What I'm going to do is we're going to read through this, and then I'm going to talk about it as we go and relate it to the President of the United States. This is, again, 1766, 9 or 10 years here before the American Revolution. The writer, Sir William Blackstone, the official guy representing the legal world of England, talking about the laws and liberties in government, doing English government. This is the government of the time when the founders were writing their documents or addressing the issues with the King of England. This is the understanding. So we're going to go under the understanding and look at the title of this. It says Blackstone's Commentaries on the Laws of England, Book the 1st, Chapter the 6th, of the King's duties. So we've got, as a review, you've got the democratic part of law in government is who? Who was it, Hunter? In American government. Considering the things that the founders were reading, the thing that Blackstone laid out is democracy, aristocracy, and monarchy. There are 3 elements of government. In England, it was the House of Commons, the House of Lords, and the King. House of Representatives was the democracy element of government. What was the aristocracy element?
Senate.
What's that?
Senate.
The Senate was the aristocracy, originally selected by legislatures for their wisdom and things like that. That's where you're going to see some things that you read in the Constitution where if there's not an elected president by a majority of votes, who elects the president? If everybody that got electors come in and say, we cast a vote for this president, Who is it that's gonna choose the President of the United States in the event of a tie? House of Representatives. Who is it who's gonna choose the Vice President in the case of a tie? The Senate. So they have different houses choosing different aspects, ambitions competing against ambitions. Okay, so those same things, they're taking what was before and modifying it a little bit for a situation that would work here. So what I'm gonna do is, let's go ahead and read this. It says, on the king's duties. So who is if they're the aristocracy, obviously who's the monarchy element of government? Sarah. In American government, if the Senate is the aristocracy and the House is the democracy, who is it, what office is it that would be the monarchy comparatively to America? The President. So we're going to talk about the volume. I proceed.
I proceed next to duties implement on the king by our constitution, in consideration of which duties his dignity and prerogative are established by laws of land.
That's good. Next time we'll just give you a microphone. Established by the laws of land. Now, one of the things that we mentioned, you read, and I read in her stuff that she put in her papers that I read this week, that the Constitution of England, I mean, is there a constitution? You know, we have a Constitution of the United States of America. You can go to an archive and try to read it. Those of you who have been there, what's it called? What's the Constitution of England called?
The Constitution of England.
No, it's the British common law.
British.
This week, reading your stuff.
Oh, man.
Are you kidding?
It comes at 2:30, feeling again.
Don't they like really not have a constitution?
Don't they really like not have a constitution?
Like,
Very good. He's even read his stuff.
accepted.
Here we go. Now, next person, Mariah. Musamere, come on, singers. Well, how would Kenny tell you to read this? That's what I want. The man, the trainer of the mover, of the moving of air. The trainer of moving of air. Here we go, Mariah. That next line that is incredibly underlined.
It being a maxim in the law that protection and subjection are reciprocal.
Okay, subjection and protection are reciprocal. What do they mean by that?
Inversely proportional?
Oh, they're inversely, they're reciprocal. It's like you do this, I do that. So it is that if somebody's going to give you protection, that you ought to abide by should have your allegiance to them. You should not rebel against them if they're the ones protecting you. Okay? So it's been said over and over again. Now I'm going to read. These reciprocal duties are what, I apprehend, were meant by the convention in 1688. Now let me tell you what happened in 1688. James II was king of England. Something went wrong. They didn't like what he was doing. He was imposing, really with the power of the sword, religion, the Catholic religion, on Protestants and people that weren't getting along with him. There's a whole lot of things that were going on in James II. And so he was deposed. And when they declared that King James had broken the original contract between king and people, that was in 1688. But however, as the terms of that original contract were, as Nick said, were in some measure disputed, being alleged to exist principally in theory and to be only deducible by reason and the rules of natural law, so it wasn't absolutely defined, written down what their constitution was. They kind of deduced what their constitution was by observation. In which deduction, different understandings might very considerably differ. It was, after the Revolution, judged proper to declare these duties expressly and to reduce that contract to a plain certainty, so that whatever doubts might be formally raised by weak and scrupulous minds about the existence of such an original contract, they must now entirely cease, especially with regard to every prince who has reigned since the year 1688. This is what the founders of American government were reading about the king and his duties. And they understood, remember, House of Burgesses is right down the street from the College of William and Mary. 1688, William and Mary came into power, and I believe that Mary was James II's daughter. And they came in, they took over the kingdom, and you know what they did? They authorized and ratified the English Bill of Rights, which very clearly set in stone those protections that the king was supposed to provide for everybody's rights. This is what was on the mind. The readers of this were the people that framed your government. So let's go to another reader. I'm going to go to the back row. Jason. Yeah, he needs to be, yeah, you're going to read this before you read the Federalist Papers. Okay, here we go. You're going to read everything except, everything in bold. The first line that's bold.
The principal duty of the king is to govern his people according to the law.
According to what?
The law.
The law.
Or to law.
Okay, the principal duty of the king is what?
To govern his people according to law.
Good. The principal duty of the king is to govern his people according to what?
Law.
What about his whimsical ideas?
Law.
Absolutely.
Absolutely not.
Hey, you elected him. What about his constituency? Should he be doing the goals of the constituency, of the voters?
No, absolutely
We sent him to
not.
office to do what we wanted. Well, if he's going to uphold his oath, he's going to do it according to law. And this is not only consonant to the principles of nature, of liberty, of reason, and society, but has always been esteemed an express part of the common law of England, even when prerogative was at its highest. Prerogative is where the king is supreme. The king is law. The king can do whatever he wants. That's what they mean by prerogative being high. There are times in England's history where the whims of the king would have their way. Even in Henry VIII, the guy chopped off people's heads all the time, stuff like that, living in moral lifestyle. There's a lot of stuff that he tried to do whimsically that he still kept in check, one, by the church and also by the parliament. So even then, when he was kind of a tyrant, didn't have the freedom to just whimsically exercise the king's prerogative. So this is the history of your president of the United States. And there's a point that I'm going to get here where I see where we may have gone a little bit amiss. The king ought not to be subject to man. This is the bold thing. So Jason, you're going to read the bold stuff right there where it says in the second paragraph, the king, says Bracton.
The king.
Yeah, keep going.
The king, said Bracton, who wrote under Henry III, ought not to be subject to man, but to God and to the law.
Stop. So they understood that the king was subject not to his constituency, but to who? God and the law. In a secular government, we're being told right now that religion should have no influence on public policy. This was a world where religion is what ought to be holding people accountable for their public policy. So after that, what's the next line that's underlined there? And then that whole underlined section after the word law there.
Oh, whoops.
Yeah, that's you. You're doing a good job.
For the law maketh the king. Let the king therefore render to the law, and what the law has invested in him with regard to others, dominion and power.
Keep going.
For he is not truly king, where will and pleasure rules, and not the law.
Okay, so not where the whimsical passions of a person are what's ruling, but it's indeed the law. In fact, if there's a national security issue, this is what bothered me yesterday. If there's a national security issue that we should act on, we should not step back thinking, I don't know if this will be politically comfortable to do right now. Those are things that come up with presidencies. That's what happened to Richard Nixon. He had a certain passion that he thought was more important for him to be in power, to be politically safe, than to obey the law. He thought there was a higher goal. His passions thought of something higher. And that's one example. So he's truly not where the king wears his pleasure rules. Keep reading, Jason, that next section that's bold, and then pause.
And again, the king also hath a superior, namely God, and also the law by which he was made a king.
The benefit here of England was you had the king accountable to God. The king was accountable to the church at the time. He was supposedly the head of the church, but he was accountable to God and the church for his confession. We're actually going to read the oath here because we're going to in some way compare it to the oath of the President of the United States. Now, the next line on this paper talked about some people prior to Blackstone having first well distinguished between a monarchy absolutely and despotically regal, which would be like Gaddafi, people that take power and then just rule with their passions. And then after the comma there it says, which is introduced by conquest and violence. So there's a difference between that and this next thing, and a political or civil monarchy which arises from mutual consent. So our monarch, our king, our executive branch is put in place by mutual consent. In fact, he's kicked out every 8 years, no longer than 8 years, by mutual consent. Keep going. The King of England must rule his people according to decrees of the laws thereof. He is bound by an oath at his coronation to the observance and keeping of his own laws. Then it goes on to talk about a statute of William and Mary, that the laws of England are the birthright of the people thereof, and all the kings and queens who shall ascend the throne of this realm ought to administer the government of the same according to the said laws. And therefore and I'm going to the bold part, all the laws and statutes of this realm for securing the established. Now listen to this. Listen to this, Parker. And look here, or on your paper. The top paragraph on page 2. All the laws and the statute of this realm for securing the established religion. Okay, so that one of the objects of and obligations of the King of England was to secure the established religion and the rights and liberties of the people thereof, and all other laws and statutes of the same now in force are by his majesty and by the advice and consent of the Lords spiritual and temporal, that's our House of Lords, like our Senate, and Commons, and by authority of the same ratified and confirmed accordingly. Now what I'm going to do is I'm going to go to, in your textbook, who's got it where they actually show, it's in the Constitution. Go to the Constitution, page 244. Page 244. Parker's going to read to us. As if he were the President of the United States, standing there with whoever the Supreme Court Justice is, hand on the Bible that tells him to not make an oath. But go ahead, and you're going to read the President's oath. This third paragraph from the top on page 244, where it says, I do. Go ahead.
I do solemnly swear that I will faithfully execute the office of the President of the United States, and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States.
The page 2.
Still the President.
Go to page 2, right here. And look at the difference. Page 2. It has an oath. It says the Archbishop will say, will you solemnly promise and swear to govern the people of this kingdom of England and the dominions thereto belonging, according to the statutes in Parliament agreed on, and the laws and customs of the same? And the king would, of course, reply in the affirmative. I do.
Now kiss the
Will you, it's going to be there eventually. Will you, to your power, at the best of your ability, right, I guess, cause law and justice in mercy to be executed in all your judgments? And they say, I will, hopefully. So, law and justice and mercy. Now look at the next one. Will you, to the utmost of your power, maintain the laws of God? This was a little bit different, huh? The founders were of the perspective of doing this sort of thing, but this is missing. In fact, the so help me God part is not in the oath for presidency, if you notice the Constitution. That was something that George Washington did. He said, so help me God. Let's look at this. Will you, to the utmost of your power, maintain the laws of God, the true profession of the gospel, and the Protestant Reformed religion established by the law? And will you preserve unto the bishops and clergy? Now, so in other words, you've got to be a Christian of a particular sect to be the king. That's what it's indicating here. Will you preserve unto the bishops and clergy of this realm and to the churches committed to their charge all such rights and privileges as by law do or shall appertain to them, or any of them? Now, this is showing an evidence, one of the evidences, that there was a difference between the church and the state. They were combined in some sense, but as far as jurisdictions in law and governance and who had prerogative to do certain things, the church was separate. There were certain things the king couldn't do. There were certain things the parliament couldn't do with regard to the church. There were things, they called it, you've heard the benefit of clergy and some terms like that. If you go to Williamsburg, they talk about how you get away with murder. If you watch, what's the Hunchback of Notre Dame, he claimed sanctuary in the church, so even though he was guilty of homicide, they could, once he was in the sanctuary of the church, cut off from civil society, he's stuck there. It's almost like imprisoned in church. They had actually a distinction that the church had certain prerogatives that the king was actually duty bound to protect. So those are two elements of this oath. But look what he says after this. All this I promise to do. After this, the king or queen, laying his or her hand on the holy gospels, shall say, the things which I have here before promised, I will perform and keep, so help me God.
And you shall kiss the book.
And he shall kiss the book.
You may now kiss the
You
book.
may now kiss the book. Okay? So, this is something that the founders of our nation were reading this. When they wanted to know what the law is and what government was, they were going to this. When they were establishing Article 2 of the Constitution, they were going to this. They actually had to look at the oath and say, well, what kind of oath should we have? So, let's look at the oath. So look at it again here, guys. It was page 244. He's swearing, okay? And the history of swearing was acknowledging that there's a judge above all, so we can trust and hold him, Christian, hold whoever's saying this oath, he's accountable to God for this. We can really only trust that what he does ultimately will be judged by God, because there's certain separations of power. Then maybe the executive could do the wrong thing. There's nothing that the government can do about it, but he will be accountable to Almighty God. So look what he said. He's going to execute the office of the president. Will do the best to preserve, protect, and defend the Constitution of the United States. It says faithfully execute the office of the president of the United States. When I look at other oaths, like the ones that pertain to to Virginia and taking office there, the governor of Virginia says that I will faithfully execute the law. Here it says, I will faithfully execute the office of president. There's actually a deliberate difference there. So the people, again, the writers of Virginia Constitution say that the executive, the monarch, would faithfully execute the law, so that he's actually enforcing it and upholding it and abiding by it. So this gives a hint of true separation of powers, where you do have, it's implied here, and we see it as we see the structure of the Constitution, that the president is bound to upholding his office, preserving, protecting, defending the Constitution of the United States. That means that he's not bound necessarily to the behaviors of the legislative branch of government. Okay? So it's very subtle, but if you read court cases about the separation of powers and when they start butting heads against each other, they call it interposition, where the executive says, well, thank you for writing that law. I'm so excited that you do that, but I'm going to ignore it. Later here in Article 2, go down to Section 3. He shall from time to time give Congress information of the state of the Union. These days he's telling the American people on television instead of Congress. And recommend to their, well, he's talking to them too, recommend to their consideration such measures as he shall judge necessary and expedient. He may on extraordinary occasions convene both houses or either of them, and in the case of disagreement between them with respect to the time of adjournment, if they can't agree on taking a break, he can tell them to take a break. And now watch this next thing. And shall receive ambassadors and public ministers, shall take care that the laws be faithfully executed. Take care, that's good, that's there. And shall commission all the officers of the United States. It says, and shall, that sounds like a mandate, commission all the officers of the United States. We mentioned Marbury versus Madison, where one outgoing John Adams wanted to have certain officers appointed to judges, and he had it be, he nominated him, the Senate said, yeah, that's good, we're gonna have those judges be put into place. And when the incoming group came into power, the Secretary of State, James Madison, refused to commission those officers. He refused to do it. So here's this instance where there's a shall do the following thing, and the presidency going, appreciate you doing that, but we didn't like what you did, and we're not going to do it. Okay? And they ended up suing, one of the judges ended up suing Secretary Madison, and the Supreme Court said, I'm sorry, we don't have jurisdiction to entertain your case. That's really what the judgment was all about, saying, oh, can't do it. Don't see it in Article 3 where we can actually entertain your complaint because the executive didn't do what you said. So, separation of powers, ambitions competing against ambitions. Now, that's my formal discussion. Act for Religious Freedom cited, so find that. And while you're looking for it, I'm going to say a speech again. I was looking at this issue about the king's obligation to protect the Christian religion. I had a conversation with somebody the other day who's read a book that goes to the Bible, goes to the Constitution, and says where the act of the founders was contrary to the Bible and a little bit usurping. I haven't read the book yet. One of the things I noticed as I was studying that and thinking about the Constitution and the First Amendment protecting or separating, keeping religion, supposedly Congress shall establish no religion, one of the things they did was they specifically said Congress. Okay, so you know what? It just meant that Congress can't establish religion. It's in that it means and it infers that the states can have a state religion. It's possible. Anything that was not given to the Congress was reserved to the states. That's implied. Now what happened is the use of the 14th Amendment has people claiming their rights as a United States citizen, not the rights of particularly the state, almost a dual citizenship. The rights of a United States citizen almost guarantee them the rights of Congress because they're falling under the laws of Congress, and the United States Constitution says Congress can't establish religion or prohibit the free exercise thereof. So the problem is we've got an executive, there's nobody in the federal government that has any purpose whatsoever to uphold the Christian religion that was the inspiration for the freedoms that it's instituted to protect. So there's a little bit of a disconnect there. If you go to Virginia Constitution, Article 1, Section 16, it says, it actually uses the word Christian religion. And it talks about the author of our religion, and the initial penning of that was the author of our religion, Jesus Christ. And then they went on to put that particular section of the Article 1 Bill of Rights of Virginia Constitution to protect religion. The author of our religion, Jesus Christ. And they took it out so that people wouldn't think, oh, we can use the power to bother other religions. So they took out the Jesus Christ yet, but they put in there and they left in there, it's a mutual duty of all to practice Christian love, forbearance, and charity. So Virginia was very, very deliberately Christian, but it was a Christian principle that would protect everybody in their religion, even if it was opposed to Christianity. Okay? So, and look at, we're going to go to the context here. Go to 57-1 that I told you to pull out. Whereas Almighty God hath created the mind free, that all attempts to influence it by temporal punishment, burdens, or civil incapacitations tend only to beget habits of hypocrisy, blah, 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 blah. Departure from the plan of the holy author of our religion, again, this is where it said, Jesus Christ, who being Lord both of body and mind, yet chose not to propagate it by coercions on either. It's by his kindness he leads us to repentance. Okay? It's the transformation of God's power that's supposed to make us act correctly. Now, if you read through this, it talks about the power of government should not be used to qualify somebody for civil office. Our civil rights have no dependence on our religious opinions any more than our opinions in physics or geometry. Now watch this. That therefore prescribing any citizen as unworthy of public confidence by laying upon him an incapacity of being called to offices of trust and emolument, lest he profess or renounce this or that religious opinion, is depriving him injuriously of those privileges and advantages to which, with his common with his fellow citizens, he has a natural right. And then it goes about talking about hypocrisy that ensues. So here's the difference of in England, the king, the monarch, was required to uphold the religion and only allow those in the office who have that particular specific Christian sect. Where here in Virginia it was like, hey, what's up with that? So the Baptist can't be governor. You know what I mean? That's really what it's coming down to. On the flip side of this, what's happening now is we have atheist, Muslim, Mormon. Now, if you don't know the details of the belief systems and where they came from, you're going, well, what's the big deal? Okay? That are actually anti-Christian. Okay, Muslim in particular. I mean, if you read the Quran, there's these 25 statements in there about jihad, and also just teachings of treating Christians and Jews and infidels, that's everybody who's not Islam. I mean, you're free to kill, ultimately, is what it comes down to. So, if you abandon the Christian principle and do not hold the king accountable to the teachings of Christ, they're more likely to exercise their prerogative, their whimsical passion, rather than upholding the law of the land. So that's my kind of political motivational speech. So you're entering into a post-Christian society with a biblical perspective. You can see the history of our government actually came from a Christian worldview, Christian accountability, the idea of man is fallen, and if it were not for God, just wiping us off the planet. Isaac, stay alert here.
I'm sorry.
Get energy to drink later. And now we're seeing the prerogative of the executive flying in the face of the Constitution, doing things to advance their passions, notwithstanding even what the constituency says, notwithstanding what the law says, contrary to the law, contrary to the constituency, and according to their own whims and passions. So I just have to tell you that and say that you've been introduced to the American government. The Constitution is not an island to itself. There's things that came before it that influenced it. And so anytime you have a question about something that comes up in the Constitution, I encourage you to read the kind of thing. What I did, I went to Blackstone and I looked up the things relating to the king. The next section in Blackstone's writing is, here, this is the king's duties. It says the next one is the king's prerogatives. And then there's other things related to that monarchical part of government. Other things you can read, just like Jason asked, you can go to the Federalist Papers, and I'm going to give you an example of that in a couple of weeks. And you can look up subjects. You go up on the internet and have the table of contents, and you can find the Federalist paper that relates to that one thing. So if you've got a question, don't use the Constitution as its own text that you're going to expound on it. Examine it against itself, but go to find those documents where those who wrote the Constitution made comments about what it meant, and also go to those things that they were reading. So that's my counsel today. And that's it.